welcome to the Hague Convention on the Civil Aspects of International Child Abduction. I'm Carrie Holmes, and along with Ron Reichstein of Youngman Reichstein PLC, we are the co-chairs of the Family Law section of the BHBA.
Thank you to tonight's program chair, who is also one of the section's amazing vice chairs, Gina Kang, for coordinating this evening's program. Before we begin, a couple of housekeeping announcements. The materials for tonight's program were emailed to you in the 1 hour reminder email and are being posted in the chat. You will receive your MCLE certificate by email within 24 hours. Please take a moment to complete the survey that is included with your certificate.
Tonight's event is the last installment of a summer mini-series here at the BHBA covering the topic of jurisdiction. We thank Jennifer Skolnick, Al Provinciano, and Ellen Stein for their hard work putting the previous two panels together. Our next episode of Direct Exam with Dan and Lauren will be on October 6th at 12:30, featuring guest Betty Nordwind of the Harriet Bew High Center. Make sure to tune in to this family law interview series on the first Wednesday of each month. We have several programs in October to mark your calendars for. We have an evening program on October 6th called PPP Loans, ERTC Credits, and Other Tax Traps Family Law Attorneys Need to Know, chaired by Jenna Spatz and featuring speakers Alexandra Leichter, Avi Reichman, and Jack Zuckerman. October 14th, 2021, in the evening, State of Department 2 will be live and hopefully in person at the Mayborn in Beverly Hills. And October 27th at lunch, Tips for Judgment Presentation, chaired by Kendra Thomas and Brian Lepak, and featuring speaker Assistant Supervising Judge Amy Pellman.
The Family Law section is sponsored by White Zuckerman, Warsofsky, Luna and Hunt, LLP, and Our Family Wizard. White Zuckerman, Warsofsky, Luna and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. They invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. Oh, I was supposed to sing all of that, wasn't I? Thank you to our presenters, and thank you to everyone in attendance this evening. Now to Gina Kang to commence this evening's program.
Thank you so much, guys. So the biggest job I have tonight is to introduce my panelists. One, we have Judge Gordon, who does not really need any introduction, but I will make a very short introduction to highlight what he's done. He has been the LA Superior Court judge for 17 years and spent 9 years in leadership positions as the assistant supervising and supervising judge of the family law and criminal divisions. And he has unique experience handling international child custody disputes and child abduction cases. That's why we have him speaking tonight, and we are very honored to have you on. He was appointed by the Chief Justice of California to provide technical assistance to California judges regarding the Hague Convention on the civil aspects of international child abduction, and was named by the United States Department of State to be one of the 4 judges in the US to serve on the international network of Hague Convention judges. Thank you very much for joining the panel.
Thank you.
And we have Peter Walzer, who is the founding partner of Southern California law firm Walzer Melcher LLP. They practice focused extensively on family law with offices in Woodland Hills. And he too does not need substantial introduction, but he has served as either a president or chair of any family law entity, bar association you can imagine, including the American Academy of Matrimonial Lawyers, the LACPA, the CalBar Family Law Section, and ACFLS. And we are honored to have you on board, Peter. And I am just Gina Kang, a partner at a small firm doing family law, but I do come across a lot of international cases, so I'm honored to be part of this panel. So Peter, if you could start the slide and get going.
So take it away, Judge.
Thank you. So good evening, and thanks to Beverly Hills Bar Association for looking at this and giving me the opportunity to talk to everyone. So we're going to go into the convention in detail. It really is kind of an overview because there's a lot of information here. It is so appropriate that it is in the topic of the mini-series of jurisdiction. There's a lot of people don't get this, but that's what it's about. It's about determining where the case will be heard. It's all about jurisdiction. It is a treaty, and the purpose of the treaty is to protect children from the wrongful effect of removal, wrongful removal across international boundaries, and to have a way between countries to assure prompt return and access to kids. The reason why it's a treaty as opposed to some other form is that sovereign nations will not necessarily observe an order from California or from another state. And what this does is provide uniformity of process, uniformity of procedure, and recognition amongst all the different states. So it's a very powerful tool, and I welcome the opportunity to talk about it. Peter, up to you.
All right, so each country who's a signatory to this treaty has a central authority, which is the main contact for parents. And our central authority is the State Department in Washington, D.C. It has a responsibility to locate abducted children and facilitate their return. So it's like a two-way street. They're a clearinghouse. You can make an application to the central authority, and the central authority receives them. And each state has an office of the central authority, and ours is in Sacramento. And so documents are transferred from the State Department to Sacramento, who then transfers it to the local office of the DA, whose responsibility is to locate the children and facilitate their safe return. So any document you submit to the central authority as part of the application, you don't have to follow any formalities. In fact, before this program, Gina and I just went to the State Department website, filled out the application, and our child is going to be returned within 24 hours. But it's not that simple, but it is a very simple form to fill out, and you can attach documents and so on, and we'll get into that later in the program. Parent need not need to present a custody order to prove their custody rights are violated. Parents without a divorce pending or a paternity action are entitled to submit their application to the central authority. You must prove parenthood or marriage to establish habitual residence, and other documents may be necessary, and there's a phone number you can call to get assistance. And whether a child should be returned does not depend on nationality, immigration status, or anything else. In fact, the law of the state of California allows for custody rights with or without a divorce petition pending or a paternity judgment or anything else.
Okay, so this is me. The countries that are not signatories to convention, as of 2019, there are 101 countries that are signatories to convention, and there are different types of contracts these contracting countries entered into for the convention, and their ratification, accession giving rise to an acceptance procedure, and their successions. How these are different, how in application you would have to further find out when you have a case that you need to do in association with the convention. Next page. So the convention, you can go to the website and see the contracting states. And what is also important is that not all contracting states are in treaty with the US. So what that means is even if a country is a signatory to Hague, US may not have a way to enforce anything with that specific country if that country is not in treaty with the US. And the list available on the US Hague Convention treaty partners always is available on US Department of State. And so you should really check it out. Don't just depend on the HCCH website that says, yes, this country is a signatory. For example, there are countries like Zambia that became a party to the convention, but is not a partner country to the US treaty. As a result, the convention is not available for resolving cases involving US and Zambia. Also, the US Department of State issues an annual report on compliance with the Hague Convention on the civil aspects of international child abduction, which provides a summary on all of the countries, including non-signatories to convention. And it includes what our central authorities have been able to do to assist these cases involving non-signatory countries or contracting countries that are not partner countries with the US.
And often we use that list of countries that are the good and bad and ugly countries to establish that maybe the judge in your local court should not return the child to that country. There's a grave risk of harm, which we'll talk about later. So those reports are very useful, and you may ask a court to take judicial notice of them.
Exactly. So the report on Japan became a signatory in 2014, but the report actually notes enforcement. While courts in Japan ordered returns under the convention, in some cases, the Japanese authorities faced challenges with enforcement, meaning, well, the children never came back. So you need to check the report out.
And that goes us into the notion of partners. And I want to emphasize the central authorities role, who's one of our biggest partners. That report by state serves another purpose too, is that within the other countries, the partner and signatory countries, they have a parallel central authority. And there is dialogue going on back and forth, both case specific and in broad terms all the time. That can include training. When we used to travel, if you all remember that, it was a while ago, we used to get on planes and go things. One of the wonderful things about being on the international network is I would get to go and train judges and lawyers in other countries to open up these dialogues and conversations and build relationships. In fact, just last week, we did a training on Zoom with judges in Brazil, and a week later, they ended up asking a question, and we were able to make the link. So the other thing the central authority does is to hopefully get some specific information and build bridges with their partners or counterparts in the other country. In California, I think we're very lucky here that we have a developed system, and we'll talk about this, and Peter will talk about this more, but these cases can be filed in state or federal. In California, especially in Los Angeles, we are, and I think positive, it's a very positive thing, that Department 2, the master calendar, the supervising judge of family normally does these cases. Not only does it get someone with expertise doing it, but it becomes a central point for all these different agencies that are involved. And those agencies can involve the State Department, Central Authority. The Attorney General in California has an office that deals with these and acts as a liaison and assistance. The other thing is we have the LA District Attorney's Office has a child abduction unit. They do a lot of great work. In fact, they appear in these cases on behalf of the Central Authority and can provide wonderful assistance, especially, and we're going to talk in a few minutes about some of the very logistical and pragmatic parts of this. And the District Attorney's Office child abduction unit becomes very important in some of those pragmatic things that you need to think about. Family Court Services can be involved, and also, why don't you go through the animations, Peter, and DCFS. There are two kinds of cases that you will see, one much more than the other. The first is a return. And a return case is when a parent seeks the child is alleging that the child's been wrongfully taken or wrongfully retained and is asking the child to be returned to that country of habitual residence. That's the most common we see. The other kind of case we see are what is known as access, which are kind of, look, I understand the child's in your Hague nation, but I want to have an order for access to the child. Almost kind of visitation-like. They're not that usual, but it certainly is a kind of case. And I think we can move on, Peter.
Yeah, I've never had an access case, but I think you put me in touch, or Judge Riff put me in touch with one of the DAs who was trying to develop a mediation program between Mexico and California. And they're trying to get that mediation program going.
Mediation is becoming a much bigger tool in these around the world.
So there are three scenarios. You can seek return from a foreign country, and we talked about how you do that. You submit your application through the State Department website and apply. You can assist a foreign lawyer, for example, a lawyer in England, from returning a child in California to that foreign country, and then you may bring an action here, or they may have filed a Hague action through their central authority. It goes to Washington, which goes to Sacramento, which goes to our local DA's office. Or you may be hired to oppose the return of a child to a foreign country. And that's another approach that you might take or you might be hired for. These are very costly. Make sure you have a sufficient retainer to cover it. And they're challenging cases and often result in a hearing, even though that's the last thing you might want.
So seeking the return from a foreign country, as Peter briefly mentioned, you have to go to the U.S. Department of State webpage to file the Hague application. So you're not running to the foreign country website necessarily, you're running to your own country's central agency to file this Hague application. And when you get to the US Department of State website, under International Parental Child Abduction tab, there is a file a Hague application button. And first thing they talk about is you really want to discuss your options with your country officer. And filing a Hague application takes you to two questions. One is, which country is the child taken to, and is the child under the age of 16? Then you click on the application. It's a 5-page document that does not request a lot of information, but you do have to have the child's basic identifying information, applicant's information, alleged wrongful takers information, and if there are any additional children, and circumstances of the wrongful removal or retention, and date of this removal or retention, and the place and circumstances. And you do need the factual and legal justification for the request. So you do have to explain that you do have the habitual residence requirement is met, and you would have to prove, you would have to submit proof thereof, such as school report cards or documents showing doctor's visits, or pictures of the child with the parent showing that the child actually lived with that parent in that location, and maybe passport issued from your locality and showing the issuance date going back. So you do need consistent records showing that the child had been in this country for at least a year. And also you need the basis of applicant's custody rights. So when we don't have a case pending and we don't have any court orders, then you would have to provide any law or statute relating to custody of the child's residence at the time of alleged removal or retention. So in family law code in California, we have 3010, which says in A, the mother of an an emancipated minor child and the father, if presumed to be the father under section 7611, are equally entitled to the custody of the child. So you would have to insert that code section and say, I do have the right to the custody, although I do not have a court order. And you do have to state your proposed arrangements for child's return or travel of the child and other persons with additional information, if there is any, and then supporting documentation and other relevant information. As Peter mentioned, you submit that through the central agency in the US, and they will reach out to the central authority in the foreign country. As Peter also mentioned, that it is very important that you reach out to the local counsel in that foreign country. Otherwise, you will end up in a black hole, and you would reach out to your country attorney, and he would say, well, I forwarded all the information and documentation to the foreign country's central authority, and you just have to wait and see. So if you do have a local counsel, that person can actually reach out to the central authority. For example, in South Korea, it's Supreme Court of South Korea, that is the central agency. So the local counsel can reach out to the Supreme Court and follow up on the progress. And I was asked to ask Peter, if a child was taken from South Korea and brought to Los Angeles, and your client filed a Hague application through the Korean Supreme Court, would she or he file anything in LA? If so, why would she or he?
That's a great question. And the Hague can be enforced privately, and you can pursue that by filing an application. Of course, you want to do this with an ex parte proceeding, and that takes me to the next slide, perfect segue. You can file in either state or federal court. And this is a tough decision. Now, family lawyers aren't really familiar with federal court, and federal judges don't get Hague applications every day. The word on the street is that federal judges are less likely to conduct a full hearing as opposed to a state court, which might have a best interest hearing. But I think the lines are pretty blurred. The procedure in federal court would be tough for a family lawyer to get through, and you might not get a hearing in a federal court for a while. Also, ex parte proceedings, which may be necessary, and ex parte with notice, may not be as available in federal court as in state court, whereas as we have a dedicated court, we have Judge Riff here to hear all Hague abduction cases. On the other hand, you're risking a best interest hearing, and it won't be called that, but they'll have to make decisions relating to domestic violence, grave risk of harm, whether the parent allowed the child to come to this country, all those issues. Of course, federal cases are covered by the federal rules of civil procedure. And the good thing about the Hague, and it allows for a certain amount of discovery. You may be able to avoid a full evidentiary hearing, but I doubt it. I'd like to hear Judge Gordon's view on this.
Well, I thank you. And I think you brought up some good points. I want to add a couple of other things. One, I want to really emphasize the second point on your slide, and this is something internationally that's a challenge. The focus is not determining best interest. It's determining what forum best interest will be determined in. This is not calling the strikes and balls, but picking which stadium the game is going to be played in. I think that you're correct that the kinds of issues here are not ones that federal courts normally deal with, but federal judges do get training and have access to the international network. I do find one of there's two challenges that you indicated that are very accurate. One is timing, and these cases are supposed to be done in 6 weeks. That's what the convention says. If they are or not, that's different, but that's the guideline. The other is that, and we're going to talk about this in a second. In fact, maybe you can switch the slide and it'll kind of go in. When you're looking for the kind of ex parte relief that Peter was talking about, the agencies that will assist could assist you. The DA's office, the police departments, DCFS, family court services to get a child interview. You don't have the parallel resources in the federal court. They don't exist. And even with the U.S. Marshal Services, which I've seen assist, it's not something they normally do. So that is something to consider. Peter's correct. This is when it's filed, it's not going to occur right away. The guideline is 6 weeks. Many times it's longer than that. But even at 6 weeks, what's the ex parte relief that you might want, or temporary orders? And that could be orders against the parent to not take the child away again. I've seen cases where the child is placed in the custody of a family member who's here, or the parent who's come visiting, a lot of different issues. It's very common, and this is something that the DA's office wonderfully does. They will take the passports once they've been ordered and maintain them of the parents and the child during it. One sec, please. And you need to think about all of those temporary things that you want in those 6 weeks. Think about, where's the child going to stay? Is there a risk of that parent taking the child again? What do you do to prevent that? I have seen orders, such as I said, temporary placement. I've seen cases where they've had the parent, the parent who has supposedly taken the child, agree to wear a bracelet, like a probation bracelet, to assure they're not going to leave. You have to be creative and think about what those temporary orders are.
A couple of things on that. I've used a process called a warrant in lieu of writ of habeas corpus to ask the state court judge to order that the DA pick up the child and turn them over either to the other parent. In one case, really didn't think out where the child was going to be, and somehow I ended up taking care of the child until my client arrived from Brazil and had to take the child to the airport. Not a position I recommend you're in, but it was that, or the child was going to stay in McLaren Hall for the night. So it was a difficult one, and I took the risk. I don't recommend that approach.
So alternate relief, UCCJEA remedies. If you have a child taken to California from a foreign country that is not a signatory to Hague, then the alternate remedy would be to go through the UCCJEA. And if UCCJEA enforcement is available, this may be actually a faster and more certain approach to securing return of the child. And you understand that no foreign countries have adopted our or America's UCCJEA. So how can we treat other countries as sister states? The international application of the UCCJEA under Family Code 3405 is available. Foreign countries are sister states if they exercise custody under factual circumstances that would trigger UCCJEA jurisdiction, and their custody laws do not violate fundamental human rights. Then you would register the foreign court order in California. You have to file the form FL 580, and you also have to file FL 105, which is the declaration regarding UCCJEA. And you need the foreign order translated, of course, if it's not in English. And you need one certified copy, and you also need another copy that may be non-certified. And you have to keep it.
Go ahead. I'm sorry. That point you just made, I'm sorry to interrupt, about translation, and we'll get to that again in a sec, is really important, because we're dealing with many different languages, many technical, it's not just translating declarations, it could be translating a code sections, are very specific. And that's something to really think about as you're preparing your case.
Sure. And as Peter and Judge Gordon both emphasized, if you do turn to the UCCJEA remedy, then you do have the greater risk of evidentiary hearing and the judge applying best interest standards, not the habitual residence. And keep in mind, you will have jurisdictional issues in this scenario. California may have emergency jurisdiction or jurisdiction to enforce, but we're not going to be the issuing state if you're registering a foreign court order. So we covered UCCJEA, modifying and enforcement, all of that on another webinar on August 18th, 2021. So please refer to the written materials from that webinar. But you may want to brainstorm which state, and state, I mean a foreign country too, is the child's home state, which state has significant connections with the child. And if you have a stolen kid, has the child been hiding in California wrongfully for over a year? And you need to keep in mind that the issuing state maintains the exclusive continuing jurisdiction. Next.
So another advantage to the Hague Convention, it allows for expedited discovery. And that might be on some of the defenses that we'll get to next, or whether the child was a habitual resident. And a big feature prior to COVID of this was allowing telephonic or video depots. Now we're so used to that that it's really not a benefit to the Hague. But before COVID, this was a big deal to get evidence into video depots. So it was a real advantage to the proceedings and very useful. Just want to mention that the automatic stay provisions of California Code of Civil Procedure 917.7 don't apply to these Hague or UCCJEA actions. So please note that you can't get that automatic stay. Do you want to comment on that, Judge, at all?
No, I think you're absolutely correct. Don't count on that. And many times, in fact, the judges will have pre-staged the return to not delay it when they're making their findings. As Peter said, and he's correct, the convention itself provides for flexible rules of evidence and authentication because you're dealing with a case that has documents from Ecuador and California, and they may be authenticated differently, may have a different form. And the goal behind the convention is to get the evidence before the court, and a judge is instructed to be flexible in rules of authentication. As Peter said before, these were cases where you would have telephonic or video appearances. Now that is something we do all the time. But it was done. You can take depots, but at least depending on the judge you're doing about it, at least when I was doing these, that 6 weeks is really important. So you've got to really stage your discovery strategically. Same with subpoenas. Be careful on, I've had people come in and say, I want a child custody evaluation. Well, that's going to take how long, right? Months and months. So I think that's not going to be occur. I do think the Family Court Services, the wonderful professionals there, I've had cases where they will do child interviews and provide the court information, and that's a tool to use. Why don't we go to the next slide?
Okay, so establishing a prima facie case for return. The Hague Convention provides that if a petition approves a prima facie case, the child must be returned unless the respondent can prove an affirmative defense. And the petitioner's burden of proof is by preponderance of the evidence. And respondent's burden of proof regarding affirmative defenses There are two. One is clear and convincing evidence for Articles 13b and 20. What they are grave risk of harm to the child, or return of the child would not be permitted by fundamental principles of the country of habitual residence relating to the protection of human rights and fundamental freedoms. So in essence, human rights would be violated. And by preponderance of the evidence, for all other defenses under Articles 12 and 13, which are the well-settled defense, the consent or acquiescence defense, or the mature child's objection defense. And the well-settled defense will kick in if the child has been living in the country for over a year.
Yeah, I remember a case where my child was seeking a move away to South Africa, and it was right during the height of apartheid. And human rights was a critical element of it. And there were people from, human rights organizations testifying in the courtroom. And I don't know if you've seen that, Judge. I guess you've seen everything, but, it was quite interesting, although it was not pleasant to watch. And especially since my client wanted to move there, it didn't help my case, I must say.
Oh, I have seen that, especially with some of the Eastern European republics. And we're going to talk about this, but keep those words grave risk in mind. It's grave risk. And we'll talk about that in more detail.
Okay. I think we can just skip this slide since we all know. I hope we all know.
So I'm going to just skip through the animations here and just lay it out. To prove the prima facie case, just look at three elements, okay? You have to prove a wrongful retention or a removal. Now, removal is pretty clear. Mom or dad, takes the kid, flies off to a foreign country, whether or not in violation of a court order. Remember, just may move away, or they may have gone to visit their aunt in, London, and said they'll return. There was a round trip ticket, and round trip tickets are a big deal, and they just don't ever come back. And you get into a big fight. Was it a wrongful retention, or did they allow me to go there? Also, you got to prove the child was a habitual resident in a foreign country, and that's if you're seeking a return to a foreign country. How do you do that? It may be a passport, it may be school records, it may be medical records, but you better have those because you're going to have to prove that they were a habitual resident, they've been here a year. And in certain circumstances, with everything online, may be tough. You may have to take screenshots that they attended school for a whole year. Pretty tricky. The removal or retention was in breach of a custody rights under the foreign country's law. Gina mentioned that code section. Parents, even without a custody order, both have custody rights under that family code section. What was that, Gina?
3101.
3101. Remember that, because it's very important if there's no custody order. And then you've got to show the petitioner was actually exercising custody rights at the time of their removal or wrongful retention. Could be very tricky to have to establish that, and it may show, something that shows the child was living with you. If there are orders, you need to indicate you took the child to school that day. Could be tricky. But if you prove those, and, it doesn't have to be clear and convincing evidence, just a preponderance of the evidence, then the burden shifts to the other side. And you got to prove the kid was under 16 years old. But you better not bring this this action when the child is 15 and a half, because if the child turns 16 in the middle of your case is over. I saw a judge shaking his head.
A complete agreement. Is a shake of a complete agreement. So as Peter said, the prong one or element one is that notion of habitual resident, that for the convention to apply, the child must have been an habitual resident of a contracting state at the time of the breach of the custody or access rights or the retention. And you have to show that the country that you're working with or seeking return is one of the countries that Jenna talked about earlier in the convention. Can you go to the next one? So as you know, a lot of the cases turn on this notion of habitual residence. And as Peter kind of said, it is very factual. The habitual residence is determined at the point of time immediately before the removal or retention. So it's not when you're in court. It's not when the child's found. It's before the alleged removal or retention. The convention does not specifically define what habitual residence is. There's a lot of cases on it. And in those cases, as we do with many things in family law, it can consider almost anything. Changes in the child's physical location where they were. Where are the child's possession? Passage of time. How long have they been away from that place? Was there a residence that the child had? Was it a house that they owned? Were they just going from place to place in a hotel? Was it just sold right before the move? Was the child enrolled in school at the time of the removal or the retention? And as Peter said, getting the records to show that. And you'll get a lot of testimony about this next one as to the parents' intent. As you have cases where the parents will say, well, we came to the United States for 1 semester for her to complete a fellowship or an internship, but we were always going to return. And the other side said, no, we were going to move forever. But that evidence of intent and what are the relationships the child has in the new location. It is very, very factually dependent and very important.
I had a case once where the mom took the child to Holland, and we were seeking return and filled out the application for the Hague return. And I also went to get a custody order in our local court because I thought that would bolster our chances of getting the child back. And the mother had alleged that dad permitted her to go, and dad had her sign a quitclaim deed to the house before she left. And the local judge in downtown Central basically said, hey, that's proof that he said she could go, and that's pretty permanent, and she had nowhere to live, and she lost her rights to the house. Denied my request. Client fired me. Then 3 months later, I met opposing counsel in the hallway, and he said, how'd you get the return of that child? And I said, I had no idea. Well, apparently the Hague process wound its way through the central authority here, went to the Netherlands. They ended up picking up the child and returning the child to my former client. So it was a little bit of a surprise, but that deed was very important, but not important to the court in Holland, apparently. So very interesting case. So what about wrongful removal or retention? As we said, you must allege that, and you must be able to establish it by a preponderance of the evidence. I love the little graphic you put on here, Judge, child abduction, silver Chrysler. I like that, get a screenshot of that. That looks pretty wrongful. But, that shouldn't be too hard to show. Article 3 provides that the removal or wrongful retention is wrongful where the breach of custody rights attributed to a person or an institution or another entity, either jointly alone under the law of the country in which the child was habitually resident immediately before the removal or retention. So this applies to dependency court cases, juvenile court cases, pretty much any case where somebody has, or an institution has a right of custody. and you have to show a violation. Much easier when there's a court order, there's a visitation or custody order, but it can even be shown without one, as we've said. And Article 5A provides that rights of custody are rights relating to the care of the person of the child, and in particular, the right to determine the child's place of residence. So I don't know if it matters whether the person has sole custody as long as they're exercising visitation. Any thoughts on that, Judge?
Yes, I think that this is a big element, and we're very used to having very detailed custody orders in a divorce case or a paternity case, a dependency case. That may be the case in the country you're dealing with, where you have very specific court orders. It may not be in a form that you're used to, and you really have to talk to a lawyer who is knowledgeable in the custody laws in South Korea or Ecuador, or wherever the country is, your Costa Rica, that you're dealing with. But in many of the countries you're dealing with, they may not be relying upon a breach of an order, but a breach of a standing statute. In other words, that a parent in that country has certain rights. So you've got to check that from both sides. A, is there a court order outstanding? And B, if so or if not, are there specific statutes in that country which provide for the rights of a family? And many of them have very specific statutes. I did a case of Germany, extremely specific statutes. England has specific statutes, and you have to check this.
And you may want to, you can get a video of a lawyer from that country to explain the law, which might be helpful in your case. I'm sure the judge has seen that on numerous occasions where lawyers from Germany or England have actually flown here to testify in the court. Now I'm
by video. Very common to have an expert in law from the other country. Very common.
Okay, exercising custody rights at the time of removal. So the petitioner must have custody rights in the country where the child habitually resided, and the petitioner also must exercise those rights. So it sort of feels like a move away case. You may have a custody order that says, yes, your client has 90% physical custody over the child, but your client may not be exercising 90%. So what is more important is there a right to the custody, and has the client been exercising that right when the child was taken? And again, as Judge Gordon emphasized many times, this is all a factual analysis, and you need to have the facts. Next.
So we've talked about this must be under the age of 16, and you may be able to be in a situation where there are several children, that mom or dad took all of the children, but you're not going to be able to get the one who is 16 years old back under the Hague. The others you may, and you may have a split where you've got children where you have to treat differently, and you would bring one under the UCCJEA, which means just registering the foreign court order and then bringing an ex parte application and showing an emergency. And the underlying deal in all of this is if the child is truly stolen, the minute you give notice, that child is going to be gone. And, this would definitely be an exception to the requirement. You cannot bring an ex parte relating to the kids unless there's, it's apparent that there could be harm to the child. So you're going to have to do this ex parte without notice. So you better be able to establish proof on that. And could you weigh in that for just a second, Judge, on these ex parte custody requests? How do you?
In a Hague case, I do think it's different. And I think that's because, exactly as you say, and many times the DA's office will be involved in that, and they become very important because you could have information. Hey, we've been we've been trying to find this person who's gone from Florida to Texas to LA. They're here in LA. We need your order of help to stabilize. And I think any court doing this will look at that.
And another point on that's, I don't know exactly related, but the question came up early. Why not just let the government handle it? Why go in privately?
Because they're not necessarily going to do it unless you go through a Hague Convention case.
Yeah. So what happens to that Hague Convention application that goes to our State Department in Washington to the Attorney General's office and down to the LA attorney? Will they operate on their own, or does there have to be a private action?
So it has to be a private. The DA will help, but not normally internationally, but it has to be a private action.
In other countries, it may be different, and there are no fees for this from the government. But in other countries, there are fees. In one case, in Sweden, I think I got a check from the Swedish government for $30,000 to enforce a court order. So check your local jurisdiction, and the government may pay you for your work.
Okay, so the prima facie case has been established. Is it done? No. There are defenses that the other parent can bring. There are specific, and these are the only defenses, and they're located in Articles 12, 13, and 20. Jen has already talked about the difference in burden of proof, which is extremely important to look at. Go to the next slide. So here's what they are. One is a well-settled defense. And the well-settled defense is, hey, wait a minute, you say that I wrongfully retained the child, but that was 2-3 years ago. And this child is here, is going to school, has got doing very well. That's what it is. It cannot be raised if the petition's filed within a year of the alleged removal. So the well-settled defense is after that. The consent or acquiescence defense is basically saying, look, it wasn't a wrongful retention. She knew I was moving here. That's what we talked about. Here's the emails, here's the deed that we sold the house. That's the defense. The next is the grave risk defense. And the grave risk defense, I think, is where a lot of the biggest policy issues and cases have been going on in the past 4 or 5 years in this. So again, grave risk, and there are 3 circumstances that grave risk applies. One is that to return the child would be a grave risk of physical harm. 2 is to return the child would be a grave risk of psychological harm. And 3rd kind of rolls over into our last one, which we'll talk about, that the child would be in grave risk because of the circumstances, be placed in an intolerable situation in the country. Some of the things that deal with are domestic violence issues, but again, it's grave risk. It's not just that domestic violence occurred, but did that country respond to it? Is there an order outstanding? Is there a restraining order? It's grave risk of harm when you get back. Risk associated with that country. You heard about South Africa. I've seen that. I had one in Ukraine when Ukraine was in conflict. Literally, there was a request to return during the middle of the conflict. Are there risks associated with the child's health? The child has a condition that can only be treated, by a specialist at UCLA or something. An interesting one there becomes about, are there siblings? And would that put the child at separating siblings, put them at grave risk of psychological? But it's not just a risk of domestic violence. And it's not a risk that the parent is subject to domestic violence. It's grave risk that the child would be impacted. That, maybe some of the same arguments, you just have to really put that case together. The next is a mature child's defense. That's really kind of like what we have, where a child can state their opinion. What a mature child is factual, but that's where the child says, look, I don't want to go back to, Costa Rica. I want to be here. And the last is the one that Jenna talked about, which is returning the child to a place which would be to a country or places that is violative of basic human rights and fundamental freedoms. Next slide.
Do you mind if I just comment briefly on that point? I've had situations where got very political in this human rights, fundamental freedoms, where, you know, certain people feel that there are human rights violated in the United States, or that I've had lawyers argue that Los Angeles is unsafe and take pictures and, you know, make a political trial, and it can get very dicey.
When you go to other countries and train, that happens all the time.
Could you just say a little bit more about that?
Sure. You have a case being brought in another country. When I was training some judges in Ecuador, they said, but wait, we look at the news, we see what's going on. And look at all the domestic violence you have in Los Angeles. Look at the homelessness. Look at the crime you have. It's not safe. So those are very real issues brought up in those other countries.
Exactly. So again, back to burden of preponderance of the evidence, very important. The well-settled defense, in other words, children are settled, they're in school, they're enrolled, mom or dad agreed, preponderance of the evidence, mature child's objection defense. We haven't talked about that much at all, but that comes up from time to time. What's a mature child? Is that 14? Could that be an 11-year-old mature child? I imagine you've seen children paraded in these proceedings, Judge, and come to the court and the parent says, my child doesn't want to go. How do you rule?
It's factual on that. I will say that defense is probably one of the least I've seen.
Interesting. Okay. And to prove a grave risk of defense and the human rights, it's got to be clear and convincing evidence. So there you have it. Pretty much covers it. And Gina, do you want to just cover what about custody and visitation during the hearing?
Sure. So, Judge, you mentioned earlier that these proceedings are designed to be handled expeditiously and that they're supposed to happen within 6 weeks. But do all the Hague Convention proceedings have the result within 6 weeks?
No.
Then what happens during the pendency of these proceedings? What happens to the custody and visitation?
The lawyers doing this have to be thinking down in the weeds, and they have to be thinking of, is there visitation? Even if there's a visitation because the other parent is in Holland, where's the child going to be safe from being abducted again? That's what we talked about before with the DA taking passports and the like. The other thing you really have to think about, we haven't talked about here, we don't have the time, but kind of what are called undertakings, which is if you order the return, how does it happen? Where does it happen? Does it happen at the airport? Will the DA's office or other law enforcement assist? Who's going to be the pickup from the person, from the returning? Are there flights that have been bought, arranged? Can the child get on them? All of those very down in the weeds things you have to think about, and really with the exchange, because that's a high stakes, high emotional incident, and you really want to make it as peaceful and appropriate for the child as possible.
Judge,
remember, in one case, the court ordered a mental health professional to accompany the child back to the habitual residence.
Yep.
And Judge, have you ever ordered a child to be kept safe in foster home so that the alleged abductor wouldn't disappear?
I've seen ordered cases where, and this has always been lucky because I've never had to have that, but where there are other family members, either a family member from the country comes here, or there are uncles, aunts, grandparents, relatives here, and that kind of placement, absolutely. So I've been very lucky that there's always been that, but that certainly could occur.
Yeah.
So there, on this last slide, we show that there are lots of resources online, hcch.net. Remember, there are 40 or more conventions, so you want to look at Convention 28. You learn about treaties on this site here, U.S. State Department site, which has a tremendous amount of information. That's where you'll make your application. And then there's an opportunity to learn about this by volunteering. And there's no cost and low cost services. They're looking for attorneys to volunteer to handle these cases in Los Angeles or in California. A great way to get experience, and buyer beware on that one. So thank you for participating in this program.
Thank you.
Thank you, Judge Gordon. Thank you, Peter, for sharing your invaluable expertise with us. And thanks again to our program sponsors, White Zuckerman and Our Family Wizard. And I think we just went over 2 minutes, and that's great.
Have a lovely evening. Thank you.
Thank you.
Thank you very much, everybody. Good night.
Good night.